Welcome to Denton's webinar on privacy regulation of de-identification and anonymization. How do we make it work in practice? My name is Chantal Bernier. I lead the privacy and cybersecurity practice for Denton's Canada. And I have with me Dr. Caleb El-Imam, who is the CEO of Replica Analytics. And I know Caleb since my days at the Office of the Privacy Commission of Canada, because Caleb was the reference for us on de-identification and anonymization. So I feel immensely privileged to have you with us today, Caleb, and enlighten us on this quite complex topic. Before we go into it, though, I have some housekeeping remarks. I want to let you know that this is a recorded webinar, so that you will have actually a link to it sent to you with other materials as may be. I also want to encourage you to put questions for Caleb in the Q&A function. We will do our best to answer them. And also, I want to remind those of you who are members of the Law Society of British Columbia, Ontario, and Quebec, that this webinar accounts for 60 substantive minutes of training. So why don't we start now with setting the stage? Because there's a reason why we are holding this webinar. It is because the legal landscape is changing in a radical fashion. Why? Because up to now, anonymous information was not within the scope of privacy law. In fact, if you look at PIPEDA, clause 4.5.3 of Schedule 1 actually equates information made anonymous to information destroyed, therefore free to use. Well, now there are restrictions on the use of anonymized information, and there is a definition of de-identified versus anonymized information. As you will see, they don't necessarily all match. In fact, even now, there is a reference to de-identified information in some privacy health legislation, but it still doesn't quite jive with the direction that you will see we seem to be going in now. So why don't we look at the first piece of legislation that has been adopted that contains provisions on de-identify and anonymize. So that's obviously Bill 64, an act to modernize the privacy laws in Quebec applicable to the private sector. And it does address de-identify and anonymize information, and it offers us a definition. So de-identify is any information that no longer allows to identify the person concerned directly. Meaning, if you sever the identifiers, let's say you lock them away, you attach only a barcode to the information, you still have traceability, and therefore it is still personal information, but you have de-identified that substantive information. Anonymize, on the other hand, is irreversibly no longer allows the person to be identified directly or indirectly. You have now lost traceability. That is anonymized information. So if we go to the next slide, why is this a historical first? Well, it's a historical first because, as I said, except for the very limited reference to de-identified or anonymized information in privacy health law, in general privacy law, there was no such definition. So now under Bill 64, first of all, as I've said, there are definitions and there are restrictions upon the use of anonymized information. So first of all, it has to be anonymized according to generally best practices. Well, that's absolutely fair, of course. But it is subject, the use of anonymized information is subject to serious and legitimate purposes. Until now, it was free to use because it was considered no longer within the scope of privacy legislation. Of course, this is fair as well. There is a provision in Bill 64 that subjects to a fine anyone who tries to re-identify anonymized information. So this is where Bill 64 is going and has been passed. But if we move to other legislation that is also tackling anonymized information, we go to the next slide, and that is the former Bill C-11. So Bill C-11 was introducing a definition of de-identify that left the resulting information to be within the scope of privacy law. And yet, as you can see here, it is fully quoted, and yet it was information that would not have allowed to identify the individual alone in combination with another form of the information. So we're losing traceability, and yet it remains within the scope of privacy law. Furthermore, while it is authorized as a use to de-identify information, it is subject, the de-identified information remains subject to uses for research and development and to be disclosed to only some specific organizations for socially beneficial purposes. So this is really interesting because the definition corresponds to what other laws call anonymized information, and yet it is treated as personal information. If we go to the next law that is sort of designing itself, and that's the Modernizing Privacy in Ontario white paper, which shows some direction that Ontario may want to go into. So then yet another tack where Ontario law would very clearly distinguish between de-identified, where some traceability remains, and anonymized, where no traceability remains, and states specifically that to incentivize innovation, anonymized information would be removed from privacy law altogether, which is in fact what we have now. But you see how we have some varied directions in terms of policy on de-anonymization, identification and anonymized information. So if we go to the next slide, what's the policy behind this new direction of legislation applying to de-identified and anonymized data? Well, the first premise is that there's a realization among policymakers that for innovation, we need to allow some use of de-identified anonymized data. But there is a great concern with respect to the risk of re-identification. And there is this position that anonymization is no longer possible because of the volume of data elements, personal data elements on the internet, and the technological capacity to match them. So it brings many to say, and among them obviously policymakers, that anonymized data or anonymization is a thing of the past. So if we go to the next slide, why don't we then try and ground this in some facts, which is precisely why Caleb is with us today. Is it really true that anonymization is no longer possible? And how real is the risk of re-identification? And what are the best practices to anonymize data, just as Bill 64 requires? So on that, I am turning it over to Caleb, who will lead us through the technicality of de-identification and anonymization.
Great. Thank you so much, Chantal. And good afternoon, everyone. So my purpose or objective for the next 10 minutes or so is really just to give you a broad overview of the identification, some basic concepts that will allow us to have a discussion on this topic, and then also give you my perspectives on where I think we are and where I think things are headed moving forward. And along the way, I hope to answer some of Chantal's questions, but I think we'll get more into depth in on those questions once we have our discussions. So can we move to the next slide, please? So let me start by describing some basic concepts. So when we look at identifiability, we think of it as being on a spectrum. And this spectrum is typically a probability. So it's a number between 0 and 1. And there are methods that have been developed over the last 50 years to quantify this probability. So when we talk about generally accepted practices and so on, there's a large body of work and many techniques that have been developed to take a data set and determine what the level of identifiability of that data set is. And these are statistical techniques, and they make assumptions. They're based on models, etc. But they work pretty well. Some are more accurate than others. Some are more computationally intensive than others, but they're pretty good techniques out there. So we'll say we can determine for any particular data set where it falls on that spectrum. And on one end of the spectrum is identifiable data. So that's data that has, say, names and addresses in them, so easily identifiable. And then at the other end of the spectrum is non-identifiable data, which is data that has a probability of 0 and cannot be linked to a real person. The concept of 0 identifiability doesn't really exist because there's always some risk that an individual can be identified, even if it's random matching of data to people. There's still not a non-zero probability of that being successful. So we generally don't want to talk about 0 risk or 0 probability. There's always some risk of re-identification. And then along the spectrum, there's a threshold which will split it into personal information and non-personal information. And if you are on the left-hand side of that threshold, then it means that identifiability is high enough that this is considered personal information. And if you're on the right-hand side of the threshold, that the identifiability is low enough that it's not personal information. And in terms of thresholds, again, organizations around the world have been de-identifying or anonymizing data for many decades. So there are a lot of precedents and generally accepted thresholds for what's deemed reasonable here to differentiate between personal and non-personal information. National statistical agencies have been doing this for many years. The Census Bureau of the US, Office of National Statistics in the UK, Statistics Canada, and so on, have used various thresholds over the years to determine what's personal and what's not personal information. So I don't think that's very controversial. What I would say is the threshold has been inching lower over time. So still within the range that people have used, but people are erring towards the more conservative thresholds over time just because of the elevated risks that Chantal mentioned. But it's not controversial to find a threshold that is deemed acceptable. Now, pseudonymous data is on the left-hand side of the threshold, so it's still personal information. It's not a probability of 1. As you move from 1 closer to the threshold, you would position pseudonymous data along the path there, where you've applied some transformations to the data set, but it's still considered to be personal information. And then depending on which terminology you use, the identified data sometimes used to refer to data on the left side of the threshold or on the right side of the threshold. So, and then anonymization is typically used to refer to data that's on the right hand of the threshold. So terminology is a bit of a mixed bag in practice. So this is why I like this diagram, because it allows us to think in terms of the concepts where data sets reside with respect to the threshold, so we can know what we're actually talking about. Okay, can we move to the next slide, please? And then, as always, when we apply data identification, we are trying to balance data utility and data privacy. There's no point and creating a de-identified data set or anonymized data set if the data is not useful for some purpose. So we always try to retain as much utility in the data so that useful analytics and useful processing can be done with the data set. The more we apply de-identification, the less useful the data will be, because de-identification involves some form of data transformation. And of course, maximum utility is the original data where no transformations have been done. So there's always a trade-off between privacy and utility, and different organizations approach that trade-off in different ways. So can we move to the next slide, please? So I think here I just want to describe to you the approaches that have been taken in practice. So in practice, we have approached de-identification as applying one or two things: transformations and controls. Transformations will take the original information or original data and apply some transformations to the data, such as generalization, where you take a date of birth and convert it to a year of birth or a 5-year interval, for example. Suppression, where you remove values, you add noise, microaggregation. There's a whole set of techniques that have been developed to apply those data transformations. And then on the control side, you would apply additional controls to manage residual risk. And these would be security controls, privacy controls, and contractual controls. Normally you'd apply data transformations first, and then any residual risk you would manage with controls. So different organizations have applied this model in different ways. So, for example, if you have a public data release, you put data on the web, then you have no controls, and you really rely only on data transformations. So to achieve a risk value below the threshold, you apply a lot of data transformations, and therefore your data quality or data utility goes down. So this is why public data tends to be of lower utility. It's because you really have to rely on transformations only, and sometimes these transformations are extensive, and therefore you end up making many changes, and you have a bigger impact on utility. What also happens is, as data complexity has increased over time, the types of transformations that you would need to apply to protect that data are extensive. So what organizations have tended to do was apply a few transformations. There'll be a lot of residual risk, and then they rely extensively on controls to manage the residual risk. So in those situations, when you have complex data sets, integrated data sets, linked data sets that cover a large part of, let's say, health data, a large part of the patient's journey, in order to really protect this data with only data transformations that would be extensive. So organizations will apply very few data transformations and then rely largely on controls to manage the risk. Of course, there's a problem with that model here, in that if you over-rely on controls, then you're essentially creating pseudonymous data or pseudonymous-like data, and then managing the residual risk using controls, which was never really the intended way risk management model was intended to be used. It was intended to apply sufficient transformations to bring the risk down to an generally acceptable level or low level, and then the small residual risk you'd manage with controls. So this is where we start running into problems, where the optics, where you rely so much on controls, become challenging, but also where not having enough data transformations means that we're increasingly using the data that looks pseudonymous and or not very far from pseudonymous, and these types of data sets are easy to attack and re-identify when an adversary gets access to those data sets. So that has created the negative narrative around a lot of techniques that Chantal had mentioned earlier on. So we need to rebalance this. We need to rebalance the risk management so that we still apply enough transformations and only manage residual risks with controls. Go to the next slide, please. So today, I think in practice, we have 4 different techniques for applying these data transformations. So the ones I've been talking about thus far are these risk-based identification techniques, which again, they work well when you have a balanced model between transformations and controls. Then you have data synthesis, which I'll talk a little bit more about in in a couple of minutes, just 1 or 2 slides to explain what it is. And then you have federated analysis and secure multi-party computation and differential privacy. And those last two, I won't talk a lot about them, except to say that they are methods that are being adopted today as well. As with all methods, they have pros and cons, and I would say they are useful under certain conditions where they provide good solutions, but they would not be good under other conditions. So you have to match your technology or your approach to the situation or the context that you're in, so you can choose the right approach that will provide you with adequate protection. So my thesis or my hypothesis or argument is that moving forward, data synthesis is the most general approach for creating de-identified data. And I'll explain why. And I think it makes sense in the context of the regulatory changes that Chantal spoke about, because it also gives us some additional advantages. But let me first explain what it is. So if we can move to the next slide. So the common way to apply data synthesis, you start off with a real data set, and then you build a machine learning model, or you fit a machine learning model or an AI model that characterizes the patterns in that source data set. And then you use that model to generate new data, the synthetic data. So the synthetic data is generated from a model that you train. And there's, if done properly, there will be no one-to-one mapping between the synthetic records and the source data, and between the synthetic records and real people. So that way, you can't really match the information in synthetic data to individuals. And we've seen synthetic data before in the form of deep fakes. So on the right-hand side here, there are deep fakes, images of fake people. These are not real people. They look very realistic, so the technology has improved quite a bit, but these are not real people. And you can apply the same technology and same approach to train models to generate structured data. So on the bottom right-hand side is a table. This is a table of data from a clinical trial. And it's synthetic data and looks very real, and it retains the patterns in the original data set. And just a couple of additional points on this are that you don't need to know how the eventual data would be applied or used to synthesize it. So you don't need to a priori know your different workloads or analytics objectives to still create useful synthetic data. So in a nutshell, that's what synthetic data is. And if we go to the next slide, and one way to make synthetic data available to data consumers is to share the models. So you don't actually have to even share the data. You share the generative models or the models that create the synthetic data, and then let the end users run the models and generate their own synthetic data sets. And this is a very different approach than the other methods that we discussed, in that the data is not derived directly. Synthetic data or the de-identified data or the anonymized data is not derived directly from the original data. It's generated from a model, and this, I think, has important implications on how we can regulate de-identified data. So there's not one flavor of de-identified data anymore. There's de-identified data that's generated from models, and there's de-identified data that's derived from real data. And I think this point will become important as part of our discussions in the rest of this session. So I'll stop here, and hopefully you have some useful background on the topic.
Thank you, Caleb. We have questions popping up, so let me start with the first one. And here it is. How do we access the generally accepted threshold when we have not developed our own internally?
So we've done reviews of those, and they've been published. So I'd be happy to share links to some of those reviews. And there tends to be consistency globally in terms of the thresholds that different organizations have used, just because everybody copies everyone else. So I would argue that you don't have to develop your own. There's some pretty strong precedents that you can rely on. They're within a range, so you can choose a value to be more conservative, on the conservative side of the range, But I'd argue that they're pretty strong precedents and for quite sensitive data. So even if your data is not as sensitive as health data, for example, if you use the health data precedents, then there would be safe precedents or strong precedents to use. So I think it's harder to justify your own if you make up your own thresholds. It's easier to rely on these precedents when you are defining thresholds.
Okay, thank you. Another one. How is encryption related to data transformation and controls? Does it fall in the same bucket?
Yes, I mean, you can argue that encryption is a form of transformation, and except that when you decrypt, your level of distortion is very small, depending on the type of encryption. I mean, some types of encryption will result in small. Well, it depends. I mean, if you're using homomorphic encryption and you perform operations on the encrypted data, then the results may not be exact, but they'll be pretty close when you decrypt them at the end. So it's a form of transformation, but with minimal distortion once the decryption occurs. So for encryption, and I'm talking about homomorphic encryption, for example, you would not need as many controls to manage the risk. But a lot of these techniques have other overheads that have to be taken into account, that just practical overheads beyond the privacy issues.
So I would like to just go back to the second part of the question, because I find it, for me, who's obviously not a scientist, I found it very helpful to help me understand. Does it fall in the same bucket? Does encryption fall in the same bucket as the other transformation techniques that you mentioned?
Yeah, so there are different types of encryption. And for the types of situations that we're talking about, I'm really referring to homomorphic encryption. This is where you can encrypt data and then perform operations on the encrypted data. And then when you decrypt it again, you get the correct result of these operations. So you do your analysis, for example, on the encrypted data. So that's what I'm talking about, homomorphic encryption, which is a very specific type of encryption. So under those conditions, I would say that's a type of transformation.
Okay, thank you. And I want to say, Caleb, that the first person who asked you the question about the transformation standards, the best practices standards, she said it would be great if you could share links. So what I'm going to do is, in the meantime, between now and when we actually post this webinar, I will be grateful if you can send us links to address that, and we will include it in the material that we share with the participants. Is that okay, Caleb?
Absolutely. I can just put it in the chat now.
Even better, even better. Absolutely. Thank you.
Okay, I'll do that.
So are you ready for the next question?
Absolutely.
So here it is. Just so is de-identified data derived from models of personal information?
Is de-identified data derived from models of personal information? Not quite. Well, it depends on the techniques you're talking about, but no, I would. So traditional de-identification, I would say the answer is no. Traditional de-identification methods don't try to model personal information per se. They try to estimate the distribution of the data in the real world, in the population, but they don't really model personal information directly. For the estimation problems, they try to model the population distributions. using some assumptions or various other techniques, try to simulate it and so on. Whereas for synthetic data, the answer is yes, definitely. You model the information directly, and then you use that model to generate de-identified or non-personal information. So I think the answer would depend on the technique we're talking about.
Okay, thank you. The next question is, just to confirm, once you anonymize or de-identify the personal information in your possession, it falls outside the data protection laws and you can retain the data forever. So this is a legal question.
Right.
So perhaps I can take that one. But under current law, PIPEDA, indeed, clause 4.5.3 of the Schedule 1 does associate data made anonymous to destroyed data. It's the only place where the word anonymous relating to information appears in the Act. And indeed, the logic is that the information no longer relating to an identifiable individual, it no longer falls within the scope of the law. In parallel, the General Data Protection Regulation has exactly adopted this provision, specifying that anonymous or anonymized information does not fall within the ambit of the GDPR because it no longer constitutes personal information. So the answer is that indeed, because it does not constitute personal information, yes, you could retain the anonymized data forever. I will make one caveat, is that should you say have a breach and that anonymized data was compromised and the OPC investigates, they may not agree with your definition of anonymization. They may say, oh, no, this was not fully anonymized because you had not completely lost traceability and therefore it was still personal data. So what constitutes anonymized information or not can be debatable according to the thresholds you were talking about. But if indeed it is anonymized, yes, it can be kept forever under current law. The next question is, how do you ensure synthetic data doesn't diminish insights available in the underlying data? What sort of limitations are there?
I think the methods for generating synthetic data have become quite powerful, and they're able to capture many of the patterns in the original data. So as a practical matter, a lot of the insights are retained, but it's not a panacea. I mean, there will be some delta between the insights you get from real data and synthetic data. If there was no delta, then you're essentially just replicating it. So the objective is really to draw the same conclusions, but you may not get exactly the same data. And then there are metrics that you can compute on the synthetic data to evaluate how able the synthetic data is to reproduce patterns with the original data. So you can quantify that similarity right away before you start applying the synthetic data. And these metrics work pretty well in practice. They're good predictors of how well your analytics will perform on the synthetic data. So I think for many situations it works quite well. I don't want to oversell this by saying that it's perfect all the time, but I think in practice it works pretty well. As with most of the techniques, most other techniques, you can find counterexamples, but I think by and far, in general, they work pretty well in practice.
Okay. So the next question is, are most other types of encryption better categorized as a security control?
I would say yes. Yeah, I mean, the context of de-identification, we're really talking about homomorphic encryption and polyomorphic, partially homomorphic encryption techniques as a type of encryption that's largely irrelevant. Other types of encryption are security controls.
Okay. The next one. is the HIPAA safe harbor method still considered useful?
It depends. So if you're an entity in the US, covered entity that's regulated by HIPAA, the safe harbor method is one way that you can check the box and claim or argue that you've created de-identified data. It's not a good method. It may have been good when it was developed quite a long time ago now, and is it more than 20 years ago? But I think at this point in time, it's not a good method to create de-identified data. If you want to check the box and you're a covered entity, fine, you can do that. And a lot of organizations will do that. But there's a pretty good chance that a safe harbor data set that you create will have a very high risk of re-identification still. And so if you're not covered by HIPAA, then definitely don't use it. It's not a good standard. So that's, yeah, that would be, I don't recommend folks to use safe harbor unless it's a stopgap measure to help you get started and move on to something stronger, which is essentially the expert determination method under HIPAA.
Okay.
Stopgap to get you there.
Well, that's clear. So this next question has a preamble, I will say, and then get to the question. So here it is. De-identification derived from data or derived from models seems to be a question of data transformation still. A model is trained through a series of computation on data. My question is, what makes a model more privacy preserving than a de-identification from data?
Well, I think it's I would ask a different question, and then to get to the point that I think you're trying to get to, it's about regulating models. So if you start regulating models and the use of models, that creates all kinds of problems. So we publish models all the time. Say in health research and other domains, any type of regression model that's built and it's published or used in an app or made available on the web or whatever. When we publish models, we're putting them out there for people to use. And in principle, if there's enough information published about the model, we can generate data from that model. And the data we generate from that model, there's a pretty good chance if it's a good model, that the data we generate from that model will look like the real data. So now if we start regulating models, does that mean we will need to regulate every model published in every publication? Because we need to regulate, what you produce from models, right? Because that would be a huge problem. It would certainly be challenging for any kind of research to exist if you're unable to publish models. The whole concept of transparency and replicability would go out of the window because you're not able to make models available anymore because now they're regulated. So that's the first concern, right? If you're able to generate data from models, then you want to regulate models. That becomes potentially very problematic. And then the other point to make is that I can create synthetic data from theoretical models as well. So I can create arbitrarily, I can define a model with multivariate Gaussian distribution, and I can put any numbers in there. So I define some model of some sort. I can make it up because I think height and weight are related in the same way, and so I make up my own model of what height should look like and what weight should look like and how they're related. So I have a theoretical model and I can generate data from that. And so this data comes from a model, again, do we want to regulate data that's generated from theoretical models versus models from data? So now we have to make a distinction between real models and theoretical models. And how real does the model have to be regulated compared to a theoretical model? Because you can have theoretical models that are enhanced with real data. So it starts getting quite messy if you want to parse all of these things out. So the difference I would argue for is difference in regulation. It's difficult and potentially very problematic if you try to regulate models, and synthetic data is generated from models. So that's, yeah, that's how I would respond to your question.
Okay, so you see, yeah, there was a further question on a previous question. Is de-identified data that is derived from models considered to be personal information? And what you're saying is that it's really a question of what the model is. Can you just specifically try to answer from a scientific point of view that question? Is de-identified data that is derived from models considered to be personal information?
If the models are created using synthetic data generation techniques and if they're done well, then the answer would be no. But that's testable, because not sometimes you can create models that just overfit and that recreate the original data. So I'm making the assumption that the modeling is done well, and if it's done well, then the data generated from these models would not be PI, and you can test that as well. So there are ways to. So the link I sent to you, for example, I put it in the chat, is one way where you can evaluate whether the data generated from a model are identifiable. So you don't have to take it for granted. You can empirically evaluate the data generated from a model to test that and convince yourself that the risk is below the threshold. Mm-hmm. But in principle, if it's done well, the risks should be low.
Okay, thank you. Therefore, the whole question is how low does it have to be to stop being personal information? But anyway, next question. It seems like the key concept missing in the current Canadian regulatory discussion of de-identification / anonymization is that of pseudonymization. This is present in the GDPR, but not in the new Quebec law or Bill C-11 or Ontario policy paper. Wouldn't the introduction of this concept go far to clarifying exactly what falls within the scope of privacy laws and what does not? Before you answer that, Caleb, I just want to say that there is an argument that, in fact, in Bill 64, the term de-identification is used as a synonym of pseudonymization, meaning information where the identifiers have been removed, replaced by any other source of traceability, but that cannot lead on its face directly to an identifiable individual, which is also pseudonymization. So there is an argument that they are synonym, but you, Caleb, have a much finer view of this spectrum than I do. It's very limited. So I'd like to hear you. Do you feel that the concept of pseudonymization is missing here in the regulatory system that is developing in Canada, and would it help?
Well, I mean, I agree with you that terminology is an issue, and sometimes de-identification and pseudonymization are used to refer to the same thing. I think there are multiple states of data. Even in the identifiable side, you can have different degrees of pseudonymization. You can have weak pseudonymization, strong pseudonymization, and so this is why I prefer to talk about the identifiability spectrum and where you are on this identifiability spectrum. But I mean, pseudonymous data has lower re-identification risk than identifiable data, original data. So there is a benefit to doing that. And I think that there should be some credit or reduction in obligations or some incentive to pseudonymize, because it's a good thing to do for sure. But it's still personal information. Mm-hmm. So incentivizing, and I from what I've seen for many years, creating incentives for organizations to implement good de-identification or anonymization practices is really important. So creating incentives for pseudonymization is good. But I think we need incentives to go beyond pseudonymization as well, to apply additional controls and additional transformations so that you can move across the threshold. And there have to be strong incentives for that, because without the incentives, then it's very difficult for organizations to justify making the investments to get there.
Yeah, well, in fact, pseudonymization is put forward as a safeguard, right?
Right.
So I will then move to the next question, because they are coming fast and furious. So to clarify, does the threshold of identifiability take into account the method of de-identification, masking, tokenization, etc., or just the nature of the data fields, data set?
So I think that one of the big differentiators among the techniques that I presented is the level of automation and the level of skills that are needed for someone to apply them. So for example, risk-based identification requires skills to apply effectively. Differential privacy in practice, a lot of organizations that have taken the differential privacy path require skills to be able to apply it effectively to make sure that they've chosen appropriate parameters, that it's used in the correct way, that they're not overusing their privacy budget, and so on. So that's one way to differentiate between them in terms of skill levels. Synthetic data generation is largely automated. I would argue it requires less skill, which is one of the advantages of it, is the level of automation to get you to a de-identified data set. So and then for secure multi-party computation, the level of skill there, depending on what you're trying to do, but a lot of these methods, encryption methods, modern encryption methods are quite novel. Some of them are proprietary. So the level of skill there to understand what's going on and understand the security proofs is quite high. And in many cases, there are very few people available who understand how these work and are able to validate that the approaches are correct. So skill level is definitely a challenge. And out of those, I mean, I would rank synthetic data requires the least skills, followed by risk-based identification, followed by differential privacy, followed by secure multi-party computation methods in terms of the skill requirements.
Okay. So going back to your very first point in your presentation, it is for the organization to choose on a risk-based analysis what is best for the organization. The next question is, how does the synthetic data that is created using the AI model mix with the personal information that was used to generate it?
So there are two kinds of synthetic data. There's fully synthetic data and partially synthetic data. If it's fully synthetic data, then there would not be any mixing of personal information and the synthetic data. If it's partially synthetic data, then there'll be a mixing of some of the original data as well as the synthetic data. So depending on which approach you use, the level of mixing will vary from 0 to some percentage, depending on how much of the original data you've retained. The privacy risks for partially synthetic data will be higher than fully synthetic data. But if you synthesize your quasi-identifiers, which are the risky variables or variables that can be used for an attack, if you synthesize those in your partial synthesis, then you'll get results comparable to traditional de-identification. So I guess the answer is there are different ways to operationalize this, and the level of mixing is a decision that can be made. The easiest thing to do is to use fully synthetic data, but there are some valid cases or situations where you would want to use partially synthetic data. Okay.
So mixing it with personal information. So the next one is, I find it really your take as a scientist, and I know that you have many clients in the private sector who rely on your expertise on anonymization and de-identification. So This next question is, do you think that the terms de-identify and anonymization, as currently used in Canadian privacy laws, incentivizes organizations to use such data minimization techniques? And if not, what do you think is needed?
I think the terms de-identify and anonymize are overloaded, and they can be interpreted in many different ways. I think what would be really helpful are two things. One is to talk about thresholds, and be a little bit more explicit about what are the acceptable thresholds, according to the spectrum that I showed earlier on. What are the acceptable thresholds for information to be non-identifiable, and then to be clear about the obligations that are attached to the information at different points along that spectrum. So having that clarity, reducing uncertainty, would be very helpful. I think using terms like de-identify and anonymize, I think the examples you presented earlier on are a good illustration, where even within Canada, we have laws that are defining these in different ways. And then if you throw in HIPAA, US laws and the GDPR, the mosaic of terms and their meaning just increases. So I think it'd be helpful to be more precise, make the obligations clear, and with that you reduce uncertainty and you make it easier for organizations to know exactly what to do. And as a concrete example, in the context of clinical trial transparency, the European Medicines Agency published a policy to make life sciences companies share their data, and they published a recommended threshold. And then Health Canada, when they published their transparency guidelines, they also recommended the same threshold as the EMA. And in my view, that was tremendously helpful because it was very precise. It was very clear what everyone had to do. Data custodians figured out ways to meet those thresholds and to demonstrate that they meet those thresholds. And then a whole ecosystem of companies popped up, which started developing technologies to automate the process and make this as easy and cost-effective as possible. So the certainty helped trigger or seed an ecosystem of innovation, and also made it easier for organizations, the data custodians, to share their data and know what they have to do. And we didn't end up arguing, or people didn't end up arguing about what was de-identified and was not de-identified, what was personal, was not personal anymore. That went away, right? We weren't having those conversations. The conversations we were having was, well, how do we meet those standards now? We know what they are. What's the most cost-effective and best way to get us there? And to the extent that we can move towards something as clear as that, I think that will be very helpful.
Okay, so clarity is the answer there. We have so many questions and we have so little time, but I don't want anybody to be disappointed. So, would synthetic data reach the level of irreversible de-identification?
I don't think the term irreversible means zero risk. And as I mentioned before, there's no such thing as zero risk. There's always some risk. So we need to define what the acceptable threshold is, and then work with that. So the common interpretation of irreversible is zero risk, and that creates all kinds of problems because it's a standard that cannot be met in practice. And again, when you have a standard that cannot be met in practice, people just don't know what to do. So I'm not a big fan of terms like irreversible. Just from a practical perspective, I find it very hard to interpret. Very small risk it would be any risk that's below the threshold. So really it comes down to choosing a threshold that is deemed acceptable.
Well, so in other words, the next question is sort of like putting all this in other words. It seems that what you're saying is that true anonymization is rarely possible unless data derived from personal information is transformed in such a way that it is not very useful. If that is true, then for most de-identified or pseudonymized data sets that are derived from personal information that still have some utility, they are arguably still personal information, as that definition is used in most legislation, because that data's information is still about an identifiable individual. Would you agree with that?
That is only the case if your standard is zero. If you want zero risk, then what you're saying is the case. But I don't think zero risk is practical. It's not reasonable, and it's not where we should be. And I don't think that was the intention. It's just the terminology used leads you to that conclusion. So again, this is where precision can be very helpful. I mean, so as an example, there've been psychological experiments asking people to translate terms like, likely, uh, uh, serious possibility, reasonably likely, and so on. Translate those subjective terms into numbers. What does that mean? Is it 1 in 10, 1 in 50, 1 in 2? What are the odds of something happening if it's reasonably likely? And there's a lot of imprecision in terms of how people interpret those terms, and sometimes the variation in how people conceptualize is so high that it's not very meaningful anymore, because it could be 0.1 or 0.9, right? So I think precision is important. I think zero risk is not realistic, and if you use zero risk standards, then it's just not a useful way to approach things. So I don't think that it's impossible to come up with low risk data sets. I mean, I think it's very possible to do it, and I think if you do it well, practically the risks will be low. They're never zero, and if you want zero risk, then you're not going to be using your data much, or using your data for secondary purposes much.
Okay, so the policy question is zero risk of identification versus zero value of research, innovation, and so on and so forth. The policymakers will have to weigh that. Another question is whether there is a standard, an epsilon value in which personal information is considered anonymized without greatly compromising its utility and accuracy, or at least what is the minimum epsilon value needed to anonymize data?
So the epsilon value is associated with differential privacy, and it's essentially a measure of how much noise you add to the data to achieve differential privacy. There is not consensus in what epsilon is. The authors of differential privacy had recommended some values for what epsilon should be, but those values would result in a lot of noise being added to data. So you typically get data that is not that has too much noise to it. So in practice, what organizations have done is they've used epsilon values that are an order of magnitude higher than the recommended values by the authors of differential privacy. Is that too high, too low? I think the jury is still out on that one. I think a lot of the decisions that have been done so far have been driven by choosing epsilon values that give you good enough utility. For example, the Census Bureau has been using differential privacy for the releasing 2020 census data in the US, for example. So they've chosen an epsilon value that they deem to be a good balance. We'll have to see over time whether that's indeed a good balance or not. But that's a very specific thing to differential privacy. I think for other techniques that are not differential privacy, we have some pretty good practical guidance. Again, the link that I sent, put on the chat.
Well, thank you, Caleb. There are many more questions, and so I think my way to summarize it and make sure that people are not disappointed, can we point people to your email address, and those who have not had the great luck of having their questions answered could reach out to you?
Absolutely. I'd be happy to answer any questions and share links and articles with folks to help them navigate this space.
Thank you. Well, you can see we really needed this. I am so grateful for your time, and I wish everyone good rest of the day. Thank you all.
Thank you very much. Have a good day.